Hello everyone. The historical Ruaraka land saga of 1984 is back again to the courts, in determination to pursue a recovery of 1.5 billion unlawful payout to the alleged claimant. A land subdivision plan, which started as merely an ambitious private housing project in Nairobi's northern edge, has now evolved into one of Kenya's biggest 3.2 billion corruption scandal, attracting public officials involved including the former CS Fred Matiang'i.
Twende mbele. Let us go and explain some of these things that have happened even before 2023, so that we can now move forward together as a country when all facts and everything has been heard and resolved. And we can deal with the unresolved matters that have not been conclusively investigated. Whether we start with Musandu, we come to Jacob Juma, we come to Kenei, we come to Rivayala and everything else. Let these things be investigated by an open public inquest, so that this is sort of Twende mbele, we explain and face the public on this issue.
The case has drawn several constitutional commissions including the EACC, courts and the National Land Commission, demanding answers about the actual owners of the Ruaraka land, in a case that was initiated back in 1984. Earlier last week, the Court of Appeal in Nairobi delivered a definitive blow to the claimants of the 3.2 billion compensation and the beneficiaries attached thereof, paving way for the EACC to resume criminal prosecutions against individuals involved, including the former CS Fred Matiang'i.
A competent court, the three-judge bench, made a ruling on this matter about 6 years ago. In that ruling, they clearly explained our role and pointed out clearly the role of the National Land Commission and the fact that we essentially were innocent on the matter because we didn't have capacity and a role to confirm that. Thirdly, the National Land Commission has got capacity, if the payment was done in error under the law, to claim or to get that particular payment that was done that day. Right now, the National Land Commission is seeking to recover about 1.7 or so billion that was paid in respect of city cabanas. I have not heard anybody calling the Minister for Tourism at that particular time city cabanas thief, as it were. And clearly they had no role to play in the matter. Besides, the peripheral role or the quote-unquote perfunctory role of the minister in this particular matter is one I played in respect of other conversations in government. When I was being excoriated on this issue, because it has been on the media all the time, I decided to go back on some of the things we did. I was the acting minister for lands when the government compulsorily acquired the building next to the office of the deputy president from an oil company. Because at that time, the National Security Council had a report that a foreign agency was trying to eavesdrop our deputy president then. So a decision was made by the security agencies, the building should be acquired compulsorily so that the deputy president is not exposed to foreign intelligence organizations. I mean, the role I played in that is the exact same role I played in the case of this particular school. So how is it that this time around I acted illegally, the other time I was acting fairly?
According to a ruling delivered by a three-judge bench, led by one Justice Karanja, Tui Yot and Wilson Karaya, the total cash amounting to 1.5 billion partial payment to a businessman, identified as Francis Mburu in 2017, was considered illegal, null and void. According to the court's realization, the 13-acre parcel of land, hosting the drive-in primary school and the Ruaraka High School in Nairobi, had already been voluntarily surrendered to the government in 1984, as a condition for a private housing subdivision. The judges found that the state cannot compulsorily acquire land that it already owns, dismissing a further 1.8 billion claim demanded by the developers. EACC therefore announced a final inquiry file from the Anti-Graft Agency regarding the criminal responsibility of public officials. The file will now be resubmitted to the DPP to initiate criminal charges against those involved. However, Dr. Matiang'i was implicated in this case as the CS of Education, whereby his ministry initiated and processed the 1.5 billion payout, ignoring the internal quality standard assessments in which the land was alleged to be a public property. In his defense, Dr. Matiang'i's role of action as the CS Education was purely procedural and administrative rather than an intention to stealing the Ruaraka land.
Under the law today, the compulsory acquisition of any public land can only be done by the National Land Commission. There is no cabinet secretary, even the cabinet secretary for lands, who can orchestrate the public compulsory acquisition of public land. So the process is very simple. The National Land Commission is the one that does due diligence, is the one that confirms everything. The Minister for Education has no land records to ascertain whether or not land belongs to the public or belongs to private individuals. This is the responsibility of the National Land Commission. When the National Land Commission has completed their work, they will ask the responsible ministries to confirm public interest before they proceed to go and make the payments, as it were. What the chairman of the National Land Commission asked the PS, not even me actually, the PS, is to present a document signed by me to confirm public interest in that school. That's a school that receives teachers from TSC. It's a school that receives capitation from government. So that is the public interest we confirmed in the school. The process of acquisition and everything else was a matter of the National Land Commission, as it were. And even then, by the way, we didn't have a budget in the ministry. It's not as if in the Ministry of Education we had a budget to buy or compulsorily acquire land. For that to happen, the National Land Commission has to communicate with the Treasury and the PS in the Ministry of Education for there to be an agreement for the Treasury to avail resources for that compulsory acquisition. So my role was less than peripheral in the matter, as it were. The PS Treasury at that time was Kamau Thuge, who is now the governor of Central Bank. My PS, Dr. Belio Kipsang, is a PS to this day. They worked on this matter together and so on. To this day, I wonder why every time, those who, my detractors and everyone who wants to insult me comes up and calls me Ruaraka, land thief, as it were.
The Ministry of Education therefore acted upon the official advice and directives of the National Land Commission to authorize a payout of the 1.5 billion mentioned in the Ruaraka land scandal. The Commission will now be pursuing the recipients of these payments to recover the 1.5 billion unlawfully paid under the fraudulent compensation scheme. However, following this judgment, Fred Matiang'i claims that the ongoing legal challenges are not necessarily judged with truth, but politically motivated, meant to derail his future political ambitions. Thank you and keep on subscribing.